Most people picture a DUI as a car, a highway, and too many drinks. California's impaired driving laws are written around vehicles and operation broadly, not just cars on freeways. The common thread is impairment and operation, and the law reaches further than almost anyone expects. California has a specific law against riding a bicycle while under the influence. It is not the same statute as a vehicle DUI, and the penalties differ, but it is a real charge that goes on your record. Rental scooters and electric bikes create even more confusion, because the legal classification of the device can change what you are charged with. And people have been charged operating golf carts, mopeds, and other small motorized vehicles. If it has a motor and you are impaired, do not assume it falls outside the law. Sleeping off a night in your parked car feels like the responsible choice, but being parked is not automatic protection. No officer has to have seen you drive. A warm engine, keys in the ignition, or your own statements about when you last drove can be enough to build a case circumstantially. Similarly, a common myth is that DUI laws only apply on public roads. They do not. California's statutes can reach a private parking lot or even a driveway. The proof in these situations is often thinner than it first appears, and that is exactly where a defense is built. You do not have to break any drug law to get a DUI. If a medication impairs your ability to drive safely, you can be charged even if you took it exactly as your doctor prescribed. Sleep aids, anxiety medication, painkillers, and muscle relaxants are common examples. Cannabis being legal to use does not make it legal to drive impaired. California has no per se blood limit for cannabis, so those cases rely heavily on officer observations and a drug recognition expert evaluation rather than a clean number. Because there is no simple figure to point to, both prescription drug cases and cannabis cases turn on contestable evidence of impairment. The 0.08% limit is widely treated as a magic line, but it is not. Under Vehicle Code 23152A, you can be charged with driving under the influence based on actual impairment, even with a lower reading. The number is evidence, but impairment is the real question. Drivers under 21 face a near zero tolerance rule that is even stricter. And California's DUI laws extend to boats as well, where the limit is the same 0.08 that applies to cars, with enforcement ramping up on summer holiday weekends. When a charge falls into one of these surprising categories, the prosecution still has to prove impairment, operation, and often the legal classification of the device itself. That proof is frequently weaker than it first looks. A careful review of the police report against body camera video and physical evidence can expose the gaps. Unusual does not mean hopeless, and it is always worth examining the proof closely. California's impaired driving laws are broader than most people realize, and knowing where the edges are can make a real difference in how you read the situation you are in. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.